the defendant. Oh, Mrs. Adelson keeps on talking. Brittany's homeless. You'll have no way to reach her. She's a homeless person. The court, Miss Adelson, stop talking. Wondered whether Vietnam had an extradition agreement with the U.S. and spoke about a conversation she had with her daughter, Wendi Adelson. One-way ticket? What, you couldn't even pretend like you were gonna come back? Like, you could at least, I know round trip is more expensive, Donna, but Donna's trying to be cheap, okay? Deposition of Wendi Adelson. As I mentioned, this has already happened this past weekend. Donna Adelson must be so angry right now. I was going through all the updates, all the court documents, and a lot of her motions were denied. Remember, we listened to a hearing that happened a couple weeks ago where there was a motion for a bond request because she said that she was having issues with where she's being incarcerated. She's being bullied by inmates, and apparently, she was trying to get her husband, Harvey, to send her stuff. That way, she would give it to this other inmate that was apparently threatening her. Now, we don't know if that's true or not, but that is what she alleged, and she testified on the stand. Now, a lot of people weren't really convinced of Donna's testimony. She went up on the stand. She was like shaking a lot, but there were times when she wasn't shaking, depending on what part of the testimony we were in. And then she also requested motion to suppress evidence. There was a phone call that she made with Charlie Adelson. This was shortly after Charlie was convicted. And Charlie hung up the phone call. Donna, on the other hand, forgot to hang up. And so, you know, usually in this jailhouse calls, it's one of those things where it's like, hey, this call is being recorded. It tells you over and over again. However, because Donna didn't hang up the phone, there were portions of her conversations that she had with her friends and, like, I think her attorney as well, that were being recorded. And she wanted to have that suppressed. However, we do have a decision from the judge, or actually a couple decisions. But not only that, there's been a lot going on. Wendi Adelson apparently had her deposition taken last weekend. And, you know, I wonder if Wendi Adelson is going to stick to the same story. I wonder if Wendi Adelson is going to ever explain as to why she decided to go to the liquor store that was completely out of her way. There was a liquor store that she was going to in order to, I don't know, she's gonna pick up some whiskey or something and then go to like an all girlfriends brunch thing. But the route that she took, if you guys haven't seen our previous videos on this case, now definitely check them out, because the route that she took was a very wild one. She could have just taken a direct route to the liquor store and then to the brunch place. However, she went all the way down south to a liquor store somewhere down here. That way, she could pass by Dan Markel's house the day that he was murdered. So did Wendi know what was going to happen, or was it just a fucking coincidence? Katie magbanua apparently may have said some things to another inmate, and this inmate is now currently incarcerated with Donna Adelson, I think. So we're going to get into a hearing about that. But yeah, we have a lot to cover. We're going to talk about Katie magbanua. We're going to look at the hearing transcript. Apparently, there's an inmate that maybe will testify for Donna, because, you know, Donna's still going to go with that story saying that it was a setup. Katie is setting us up. We had nothing to do with this. This is blackmail. This is extortion, blah, 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 blah. It's actually really crazy that she's going to continue going with the same story as Charlie Adelson. Charlie Adelson was found guilty. But you know what? Instead of throwing Wendi under the bus, you know, if Wendi's guilty, or maybe throwing Charlie on the bus, say, you know what, it was fucking Charlie. Charlie fucking did. I had nothing to do with it. You know, I hated Dan. I hated his guts. I wanted Wendi to come live with me, but I didn't do anything. I didn't orchestrate anything. You know, I was just being told what Charlie was telling me to do. I don't just like start throwing each other under the bus, because I don't think that it's going to be a tough one for Donna. Very, very tough. And I can't wait to watch the trial and then see if there's any new evidence they have against Donna Adelson. So we're going to go over Katie magbanua. We're going to go over the motions that were denied. So it was a motion to suppress evidence. Again, it was the electronic recording. Was there anything else? I think that was it. And then it was a motion to deny, it was a motion for a bond, because Donna wants to be out on bond while she waits for a trial. And there was a bunch of other mini stuff, but there's a lot going on with this case. So I just want to update you guys. And let's just do a major, big fucking update today. Let's just do that. I'm digressing here. So let's jump into this. Let's talk about Katie magbanua. She's going to have her deposition taken April 3rd. Now, remember, Katie magbanua wasn't really willing to testify against the Adelsons. It wasn't until she had her second trial, because she had a first trial, but it was a hung jury. She had a second trial. That's when she was found guilty. And she actually came in to testify. Oh gosh, because I don't know if I watched her testimony, but I had COVID for the first time when Charlie Adelson trial was happening. So I watched like like the major parts of it, but not everything. Now, I think it was during Charlie Adelson's trial that she finally decided to testify against him. Maybe the state offered her a deal like, hey, you know, maybe we'll make your conditions a little bit more comfortable, you know, because you're going to be here for the rest of your life and it's going to fucking suck. I don't know. I don't know what offer they might have given her. So she is going to be testifying, it seems like, for Donna Adelson's trial as well. And it seems like even Charlie's going to testify. I wonder if Charlie's going to be like, you know what, Mom, fuck you. I'm going to look after myself. I still got another 60 years. You know, I have a child that was born. I think like his kid is maybe like 5, 6, 7 years old. So Charlie technically has like a whole life still ahead of him. I wonder if he's going to throw his mama under the bus. Maybe he should, you know, maybe he should try to take a deal or something. But, you know, honestly, it's really too late for him because I know he was trying to appeal. I don't know what's going on with the appeal stuff, but he honestly should have just thrown her under the bus. But here's the thing with people like Charlie Adelson, Donna Adelson, people like them, they think they are untouchable. They think that they are above the law. They think they are cunning, convincing. Like Charlie honestly thought that he did a really good job during his testimony. And so when he was found guilty by the jurors, he was, it seems like he was in shock. They were very surprised. All right, so I wanted to read this hearing. It seems like, from what I glazed over, it seems like there is going to be a witness who's going to be willing to testify for Donna. However, this witness may not be potentially a reliable witness due to some, I think, some drug issues that they may have. But apparently they were incarcerated with Katie, and they claim that Katie said some statements that might help Donna's case. Again, Donna's going to go with, oh, it's extortion, you know, we're blackmail, blah, 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 blah. Same thing as Charlie's argument. Proceedings, the court. So the court has an amazing deep voice that I can't replicate. So I just want to let you guys know, but we'll do our best reading this, okay? Get started. State versus Donna Adelson. This is defense's motion to perpetuate testimony. Mr. Zellman. Good morning, Your Honor. The court. Good morning. Mr. Zellman, I think I want to step up there. It doesn't appear that this microphone is working. The court. Go ahead. Mr. Zellman, Joshua Zellman on behalf of Ms. Adelson. Your Honor, we filed an expedited motion to perpetuate testimony concerning anticipated testimony of 2 potential witnesses. They have been identified in the motion as Cassid Conroy. I don't know if that's how you pronounce it. If y'all know how to pronounce that name, let me know. And Brittany Purcell. They've been given statements to Ms. Adelson as well as a temporary investigator that we retained for that purpose. Namely, as I identified in this motion, their testimony concerned statements that were made by Katie magbanua while she was incarcerated at Leon County Detention Center pending her 2 trials. The court. Before you continue, Mr. Zellman, why was not all of this actually contained in the pleading itself that you're laying out right now? Mr. Zellman, I didn't want to put everything in the written motion, Your Honor, since it gets played over and over and over in media and podcasts and whatnot. The court. Forget the media. I'm going to the sufficiency of the pleading itself and what the rule requires. Does this pleading meet the requirements of the rule itself? Mr. Zellman, I would say yes, Your Honor. The issue is the rule requires after the filing of the indictment, the defendant or state may apply for an order to perpetuate testimony. The application shall be verified or supported by the affidavits of credible persons that a prospective witness resides beyond the territorial jurisdiction of the court or may be able to attend or be prevented from attending a trial or hearing. The witness testimony is material, and that it's necessary to take the deposition to prevent a failure of justice. Your Honor, the statement and the materiality of their anticipated testimony concerns the motives and or the bias of the state witness. Catherine magbanua anticipated testimony at trial covers those issues. The motive and or bias of the state witness is always going to be relevant and the material for purposes of cross-examination, and certainly concerning the statements that we have at issue here. Oh shit, oh no, hold on a second. Guys, I'm so sorry. I'm gonna have to edit this in post because I had the wrong screen up. Oh my God, I'm so sorry. I was like, wait a second, why is this not scrolling with me? Yeah, note to self, I'm gonna have to re-edit this video. I'm gonna have to fix that. So I'm reading this transcript here. Yeah, this is the transcript that I'm reading. I'm sorry, y'all. Let's see. The witness is going to be relevant and material for purpose of cross-examination, blah, blah. The court. Why these individuals cannot be available is really going more to the heart of this. Mr. Zellman. Well, Your Honor, the concern that we have is based on their track record over the last X number of years and statements that they made to Ms. Adelson. Our concern is that they will not be available because they will go back to using drugs and will not either potentially not be able to be located or may not be competent to testify, depending on the condition that they are in at the time. Well, that's not good. The issue for the purposes now is that they may be unable to testify. We certainly understand subpart 6 of the rule that no deposition shall be used or read into evidence when the attendance of the witness can be procured. We're certainly going to attempt to serve them. We're going to make a good faith basis to get them to be physically present so that we don't have to use their depositions for perpetuated testimony at trial. However, in the abundance of caution and to prevent the failure of justice, given the nature of the statements that these women have repeated to us from Ms. magbanua, we believe that it's appropriate and necessary to attempt to preserve their testimony. There is also a case law out there, Your Honor, that finds it is very ineffective assistance of counsel not to make this attempt. It is also a reversible error for the court to deny a motion to perpetuate testimony when the anticipated testimony is both admissible and material. The court. All right. As to the issue whether these women will use drugs again, how is this no different than any other person who has a drug-related crime or background in the county jail? Mr. Zellman. I don't necessarily believe that it is, Your Honor, but in my experience, trying to track somebody down who is actively using drugs in order to serve them and to ensure that they're present in court can sometimes be difficult. Yeah, I fucking bet. The court. Any evidence that you wish to present in support of the motion? Mr. Zellman. Aside from what we have, Your Honor, if Your Honor would like to hear from Ms. Adelson concerning the statements that have been made, Ms. Fulford is prepared to conduct a brief direct. The court. Very well. Ms. Adelson, please raise your hand. Ms. Adelson was called as a witness, having been first duly sworn, was examined, testified through Zoom as follow. All right. So by Ms. Fulford, this is direct examination. So I guess it's another one of her attorneys. I don't know what any of her attorneys' names. Ever since her team of attorneys have been replaced, I only knew Daniel Rashbaum, and I forgot who the other attorney was that was also replaced. Oh, gosh, guys. Okay, so not only was her entire team replaced, there was a private investigator that recently as well, they cannot use him to assist further with Donna Adelson's case. Oh my gosh, Donna must be so fucking pissed. I'm telling you, she's not happy right now. She ain't happy. All right, so direct examination by Ms. Fulford of Donna Adelson. Ms. Adelson, during the course of your incarceration at Leon County Detention Center, have you become aware or familiar with a witness named Cassie Conroy? Ms. Adelson, yes, I have. And during your time incarcerated in an area that is close to Ms. Conroy, who's also incarcerated, have you engaged in discussions with her where she was indicated that during a time she was previously incarcerated, she was also there in close proximity to the state witness, Catherine magbanua? Yes, she told me that. Okay. And during the course of your conversations, have you learned that Cassie Conroy had an issue with the use of illegal drugs and an addiction problem? Yes, she does. Okay, and speaking with her, have you learned that she's going to be released around midnight this Friday, January 31st? Oh, so they're already released. Or in the early mornings of hours of February 1st, 2025. Yes, that's what she told me, yes. Okay, and based on the conversations that you had with her, based on what she had told you, do you have a concern, in fact, that she will be unavailable to testify in your trial in June? Damn, in June? Oh, it's coming up soon. Based on her prior addiction and her comments that she intends to continue her use of drugs when she's released? Yes. Okay. And during your conversations with Ms. Conroy, has she indicated that while she was incarcerated with Ms. Catherine magbanua, sorry, I was like getting paranoid. I was like, I'm hoping, here, I was zooming for you guys. I was like, please make sure I'm on the right page. Okay, here we go. In case you guys want to follow with me. Hello, Golf Girl. How are you doing today? Oh, no. Get the notifications on. You know, you can join the Discord too, and you can have the notifications on in Discord. That way you get doubly notifications. I don't know. I hear people talking about that with YouTubes and the unsubbing thing. Donna talked about converting Dan Sheridan to Christianity if he dressed up in Nazi uniforms. Yeah, I can't wait to see more Donna Adelson emails. Okay, that woman is unhinged. She crazy. Now she's trying to play as like, oh, poor me. I'm just a poor old lady. I don't know any better. Oh my gosh. Poor lady who's being extorted by all these other people. And Donna's, I'm telling you, Donna, when she testified a couple weeks ago, I was like, dude, she's pretty fucking good. I think she was pretty convincing. Was I convinced? No, I was not convinced, but I think she did a really good job being convincing as she was testifying. So we'll see if the jury buys it. Okay, so where am I? Okay, attorney. And during your conversation with Ms. Conroy, has she indicated that while she was incarcerated with Katie magbanua, that Ms. magbanua provided information to her to the fact that she intended to set up the Adelson family in hopes that she would get a reduced sentence after she was convicted? This is so leading. Ms. Kappelman, objection, leading. Court sustained. This needs to be drawn out as direct questions. Dude, that was like, is it like compound and leading? All right, Ms. Fulford. Thank you, Judge. All right, Ms. Fulford, take your time now. We got 10 pages. Let's go, baby. What statements has Ms. Conroy made to you regarding what Ms. magbanua has said about her hopes of attaining a reduced sentence? Adelson. She said, wait until I come back. I'm going to take care of that family. Wait till they see that I'm going to get a reduced sentence. Okay, and is it your desire that Ms. Conroy be available to testify at trial regarding the statements that Ms. magbanua had previously made? Absolutely. Okay, and likewise, have you become familiar while you were incarcerated at the Leon County Detention Center with Miss Brittany Purcell? Yes, I have. And during your discussions with Miss Purcell, did you indicate whether or not she had prior addiction issues? Yes, she has. And based on your conversation with Ms. Purcell, do you know whether she has indicated she continues or intends to continue her use of illegal drugs upon her release? I take an art class at the jail, and she has said it is in the... Wait, what she said now? I take an art class at the jail, and she has said in the art class as well. That's her intention. You know what? I think Donna Adelson and Sarah Boone might do a good job being in art class together. You think they would get along? Okay, and do you know when it is that Ms. Purcell is supposed to be released from the Leon County Detention Center? You know, I think she said early February. I don't know her exact date. I didn't want to question her. Okay, and based on your discussions with her, did Ms. Purcell indicate that she was familiar with Catherine magbanua from prior incarceration time? Brief pause. Ms. Adelson, please respond. I can't hear. Was a question asked? I didn't hear anything. Please ask the question again. Thank you, Judge. She asks the question again. Donna Adelson says, yes, she did. Okay, and based on your conversation with Ms. Purcell, did she indicate what statements, if any, Ms. magbanua made to her or in her presence about the Adelson family? Yes, she's made several statements. And what were those statements? She said that she had her plan worked. She would not be here where she is. She would be sitting pretty in Hawaii, drinking a fancy drink. That was one of her statements. Okay, and what other statements did she make about setting up either Charlie or yourself or the Adelson family? Kay, they call her. I called her Katie, but they all refer to her as Kay. I guess that's the name she used when she was here. But they said, Brittany said to her that Kay made it very clear that she was blackmailing Charlie, my son. Okay, all right. Anything further that was said? Yes, I guess I should have been prepared. I didn't know I was going to be asked. I'm just a little nervous right now. But she spoke, she spoke about the tattoo. She spoke about the tattoo that Kay had and about a tattoo that her child's father had of her with the machine gun that he put on his body, of Katie with the machine gun. Sounds like a very interesting tattoo. Would it be your desire that at your trial in June that Ms. Purcell be called as a witness if Ms. magbanua testifies in this case? Yes, I would like her to be there. Absolutely. And do you have a concern based on her drug addiction and her intention to continue drug use after she is released that she will be unavailable to testify at your trial? The YouTube thing, you can subscribe and resubscribe. Sometimes it helps, but you also have to make sure your notifications are not set to all. Yeah, I have to do my notifications. But what does personalized notifications mean? I never understood what that meant on YouTube. So when there's channels that I follow and I want to get their notifications, I just hit the all button. But what does personalized mean? Is it just like YouTube just thinks you might like this video, and if they think you like the video, then they'll recommend it? Like, how does that work? All right, so question. And do you have a concern based on her drug addiction and her intention to continue drug use after she is released that she'll be unavailable to testify at your trial? Adelson. Yes, that's my concern. It's a big concern. Miss Fulford, may I have one? Maybe just a moment. The court. All right, go ahead. They're discussing things off the record. Miss Fulford, I don't have any additional questions at this time, Judge. Thank you. The court. Ms. Kappelman, Ms. Dugan, any examination. Oh, yes, cross-examination. Let's go, baby. By Ms. Kappelman. Oh, I can't wait to see Ms. Kappelman for the trial. Mrs. Adelson, when did these women make these statements to you in the jail? Well, at different times over the last, Casside, it was back in October. Brittany was after that. Brittany, I think, was around Thanksgiving. I didn't write down a specific date, but it was over the last 2 months or 2.5 months. Wait, you didn't write a specific date? I feel like this is important. You will be documenting everything. Mrs. Kappelman, no further questions. The court, any redirect examination? No, Judge. No, thank you. That will conclude the testimony. Is there any other evidence the defense wishes to present in support of this motion? Mr. Zellman, no, Your Honor. Response from the state? Judge, the state objects to the defense's motion. We do not think they have laid sufficient grounds for a motion to perpetuate. As Your Honor hinted at or pointed out, almost all civilian witnesses in criminal cases engage in high-risk behaviors and may be unavailable in that sense. I don't think this is any different. We have no evidence to suggest that these women are going to be high all the time or unable to be located at the time that they're going to be asked to testify. So I would object on that basis. Secondly, I think, timing-wise, I have an objection. I don't think it's fair to the state to spring these witnesses on us. I learned about them Sunday when the defense's motion was filed. I don't think they've been officially discovered yet, but I learned about them when I got this motion Sunday night. In order to depose these witnesses, presumably, and somehow be prepared to cross-examine them the next 2 business days, I don't think that's sufficient time for me to prepare an adequate cross-examination. By the way, this hearing took place back in January, but they recently, transcribed it for the public. I don't think this was ever on a live stream or anything. I don't remember it. All right, Georgia Kappen. I don't think that's sufficient time for me to prepare an adequate cross-examination nor to depose them, as I have a right to do. Prior to conducting that cross-examination or sufficiently investigate them or their stories that I'm just learning today. Because as Your Honor pointed out, the testimony and substance was not even present in the motion itself. So we're all just learning about it today. Yeah, because the attorney for Donna Adelson was like, well, I didn't want to put it in writing because, the news, the media, they're covering this, the podcast. And the judge is like, who fucking cares? All right. So for all those reasons, I would object to moving forward as suggested by the defense. The court. Any further arguments, Mr. Zellman? Mr. Zellman? Nah, just a moment, Your Honor. So now they're discussing off the record. Mr. Zellman, Your Honor, with respect to the rule, contrary to the state's position, the standard is may, it is not will be unavailable. I think Your Honor's concerns expressed at the beginning of the hearing would be spot on if the standards were will be unavailable. However, the rule includes language that says may be unavailable. Now the rule, the judge cuts him off. As to the very point, though, Mr. Zellman, could we not say in nearly every trial someone who is scheduled to testify may be available? Therefore, now this deposition instead of testimony taken under oath during the trial itself? Mr. Zellman. Yes, Your Honor, but there's... Oh, gets cut off by the judge again. An asteroid could hit... Oh, we talk about asteroids now. Okay, let's not talk about asteroids. There's this video that I watched about an asteroid that's supposed to maybe hit Earth in 2032. But anyways, that's digressing. An asteroid could hit Earth. There could be a car crash. There's no extent that could end the maybe unavailables. Mr. Zellman, that's the plain language of the rule, Your Honor. The court. Keep your hand down, Mrs. Adelson. Oh, she's raising her hand up. She's like, let me speak. Let me talk. I want to talk over here. Mr. Zellman, just because we perpetuate their testimony, there is still a second part of the analysis as to whether or not the perpetuated testimony can be presented in trial. That's in subparagraph 6. We still have to make an attempt to procure their testimony at trial. This is in the event that we're unable to do that. Your Honor, the temporary investigator, it took us some time to find somebody who did not have a conflict. We actually had to go somebody out of town that I've used in the past. She actually works at the federal defender's office in Georgia now. We didn't get her summary of the interviews until she conducted on Friday until Saturday. So over the weekend, we obtained that information, prepared the motion for perpetuation of the testimony on Sunday. I emailed to the state Sunday afternoon, the court. Very well, having reviewed both the rule, and I'm referring to Rule 3.190I, that concerns motions to take the depots to perpetuate testimony, having heard the testimony of Mrs. Adelson today, as to the material nature of this testimony, and also the argument of the parties, I am prepared to rule. Oh, cool. I love it. I love it when they rule. As it concerns the language, may be unavailable to attend or be prevented from attending the trial or hearing, Mr. Zellman, as it pertains to your argument that it is not will be, but maybe, it is well taken. That is the plain language of the rule. I would still say, as I'm interpreting this rule, it still has something that goes beyond what is merely speculative. These witnesses, while they may have used drugs in the past or may use drugs in the future, that does not render them, based on my reading of this, that they are unable to attend or prevented from attending a trial or hearing. or maybe merely because they may use drugs again. If this was a situation where we were dealing with someone such as a military deployment or someone who is dealing with, because I was wondering what are some situations that would require them to do the perpetuate testimony then? And I like how the judge gets into that so he answers our question. So here are some scenarios where they would do that. If someone was in a situation where they were being deployed for military service, or someone who's dealing with a grave illness or something that is more concrete than just this person may use drugs again in the future, I think would be a little bit more firm footing. This is, as I find it, speculative that because they have used drugs before, may use again, they cannot testify during trial. These witnesses should be subpoenaed by the defense to secure their testimony at a future trial date. Are you allowed to pay people to testify for you? Not experts, but like normal, regular people? Probably not, right? Like, it's like, hey, I'm Donna Adelson. I'm so fucking rich. Come testify for me. I'll give you guys money. I don't know. I just had to have questions. Probably not. If the situation changes where we are no longer dealing with something that is completely speculative, I will readdress the motion. Or like, can you pay for their expenses? Actually, don't. I'm going to look this up. I'm actually very curious. Oh, hi, Michelle. How are you doing today? Michelle's like, why are you talking so fast? Okay, I'll try to slow it down a little bit. But I do recommend, if I do talk too fast, you can make it slower on the YouTube player. So the cool thing is, I don't know if you have the... Actually, you know what? I think YouTube rolled out a new feature now where instead of just being stuck at like 1 times speed 1.5, you can actually do like micro adjustments. So if it's too fast for you, you can always slow it down. I like this judge. I've been liking all the judges so far. There's one judge out there that I'm not a huge fan of, and y'all know who she is. But yeah, I like this judge. I love the judge in the Corey Richards case. I love the judge in... Who else is coming up for trial? Corey Richards judge. The Idaho 4 murders. I like the new judge that's been assigned. Speculative. Okay, so let's continue with what the judge was saying. This is, as I find it, speculative. That because they have used drugs before and may use drugs again. They cannot testify during trial. These witnesses should be subpoenaed by the defense to secure their testimony at a future trial date. Wait, I have a question. Who do you think speaks faster, me or lawyer you know? Because he speaks actually pretty fast. I like his speed when I'm watching him. I don't have to speed him up or anything. Unless we're doing like court react stuff. But I think he speaks pretty fast, in my opinion. These witnesses should be subpoenaed by the defense to secure their testimony at a future trial date. If the situation changes where we are no longer dealing with something that is completely speculative, I will readdress the motion, but I'm going to deny it. Mr. Zellman, Your Honor, may I just point out that the statements that both of these witnesses have made indicated their intent to continue to use drugs upon their release? The court has made to Mrs. Adelson. However, that does not mean they're going to be unable to attend or prevented from actually showing up for the trial during June 3rd. Mr. Zellman. Yes, sir. Your Honor, may I just have one thing? No, ma'am. Is that Miss Adelson? Did she try to say something? Oh, gosh. Court was like, nope. Eek. Mr. Zellman. Ms. Adelson, if you could just give Ms. Fulford a call, we can discuss further. The defendant. Oh, Mrs. Adelson keeps on talking. Brittany's homeless. You'll have no way to reach her. She's a homeless person. The court. Ms. Adelson, stop talking. As to the motion for a change of venue, are the parties capable of arguing this today as well? Mr. Zellman. No, Your Honor. The court. Very well. We're in recess. Mr. Zellman. Thank you, Your Honor. Okay, and that concludes. Judge tells her to shut up pretty much. All right, so that is the hearing transcript for this. I think this was back in January, if I remember correctly. Yeah, back in January 29, 2025. So again, just a recap of that. Katie McBanua was going to have her deposition taken in about a week or two. And apparently, Donna says that she was incarcerated with 2 other women, where they were also incarcerated when Katie McBanua was at Leon County jailhouse. I don't know the correct name for it. And apparently Katie made statements saying that, you know, she was trying to get back at the Adelsons, that she was trying to testify in order to, you know, have things better for her, and possibly, I don't know if they mentioned like the blackmail thing, but that was basically the effect of that. Because again, it goes to Donna's defense, which is, I'm being extorted, just like my son Charlie. I wasn't involved in the murder of Dan Markell whatsoever, even though I was making payments to Katie McBanua and I was writing those fucking checks and she wasn't working in our office. But, you know, we're just paying her. What do you mean? She was our housekeeper on the weekends. No one saw her. Anyway, so there's that. Next one. Deposition of Wendi Adelson. As I mentioned, this has already happened this past weekend. I wonder if there's going to be any new information with Wendi Adelson, or if it's going to be the same old thing, you know? Going up there to testify, saying, I had nothing to do with this. I didn't know anything about the $5,000 or the TVs. You know, I don't know why I took the long way to go to the liquor store. I don't know why I went by Dan Markel's house and I didn't see anything. There was tape. What do you mean? So I wish we could have a copy of her deposition. But we'll see her testimony in trial again. All right, so what is this? Defendant's motion in limine. So it seems like the state wants to introduce a Exhibit 60, which is called the divorce filing. Remember, there was a divorce that was happening between Wendi Adelson and Dan Markel. And a lot of the times when people are covering this case, it's always like the contentious divorce. You know, they were fighting for custody. It was so contentious that, you know, they were firing at each other back and forth, and it was wild, and Wendi wanted to relocate, but the judge denied it, and then Dan Markel didn't want Donna to be around the children anymore, just by herself, because she was making these statements to the kids, and so they want to include the divorce filing. Now, what I thought was really interesting, and I don't know if you guys saw the community post that I made or the post that I put in the Discord, but apparently, this was what caught my eye. The false narrative that the divorce was a bitter custody battle. Hold on. So are they saying that the custody battle between Wendi and Dan was not bitter? That it's just all a lie made up by the state and maybe friends and family members? I don't know. Very interesting. So by this motion, Mrs. Adelson moves to exclude and or limit State's Exhibit 60. Additionally, the documents which contain hearsay are inadmissible. The divorce file contains over 560 pages. It is significant that Mrs. Adelson was not a party to the divorce proceedings. I wrote a note here, or was she? I feel like Mrs. Adelson was so involved in her child's life that maybe Dan Markel was also divorcing Donna Adelson as well. The divorce file is over 560 pages long, and the only significance the undersigned can fathom is that the state desires to use the size of the divorce files to support their false narrative that divorce was a bitter custody battle. I thought everyone agreed that it was a bitter custody battle because there were emails between Donna and Wendi, and they obviously hated Dan Markel. They despised him. The state has asserted that the statements contained in such filings go to the motive of the defendant then on trial. Although such an argument could overcome the relevancy issue addressed above, the state must still establish their admissibility as either an exception to hearsay or as non-hearsay. Again, this is the defense's motion in limine because they want to exclude the court doc. So we're going to listen to the defense's argument for that. The state of the mind exception to the hearsay rule does not extend to the admission of the divorce file in its entirety. The state of the mind declarant is a subject of the exception in the section blah, blah, blah. It only applies to the declarant's state of mind rather than the state of mind of the defendant. So the declarant, in this case, it's going to be the grandchildren because apparently the grandchildren, there was something that was told by the grandmother. The grandchildren told the dad, and then the dad was like, oh, hell no, she's not talking shit about me while I'm not around. With respect to Mr. Markel's March 26, 2014 counter motion for enforcement, the motion contains 8 specific requests. Only one of these requests apply to Mrs. Adelson. Namely, the motion identifies statements allegedly made by Mrs. Adelson to or in the presence of her 3- and 4-year-old grandchildren. I don't understand. If these statements that she made to the grandchildren were true, who does this? Who brings in 3- and 4-year-olds into this bitter custody battle? Her 3- and 4-year-old grandchildren later allegedly repeated those statements to Mr. Markel. Statements purportedly made by Mrs. Adelson are admissions. However, statements made by her grandsons to Mr. Markel are hearsay. The statements in Mr. Markel's court filings are also hearsay. Section something for statutes requires the proponent of the statement to assert valid exceptions to each level of hearsay to render the statement admissible. With respect to the alleged statements repeated by the 3- and the 4-year-old grandchildren to Mr. Markel and to which Mr. Markel placed in the court file, there are 2 levels of hearsay. The state must overcome the documents for it to be admissible. Even if there is an exception for one level of hearsay, there's no exception for the second level of hearsay. So again, the first level of hearsay is the 3 and the 4-year-old repeating it, and then the second level of hearsay is Dan Markel putting it in the court file. The state has previously argued that Mr. Markel's statements in the court file were not hearsay pursuant to Section 90, blah, 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 Florida statutes, because they're not being admitted for the truth of the matter asserted, but rather it goes to the defendant's motive. Again, Donna wants the grandchildren and wants Wendy to be closer. That way she can pull the puppet strings, she could be controlling, take over. In these such circumstances, statements by Mr. Markel in the counter motion and other filings would not be hearsay to establish Mrs. Adelson's state of mind if the state can establish Mrs. Adelson knew the statements had ever been made. I mean, obviously, Donna Adelson is going to be like, I never made those statements. What are you talking about? How could I have known these statements were ever made if I didn't make those statements? I could totally see Donna doing that. And that's it. So that was filed by the defense on March 10th. I don't think the state has replied to that yet, so we'll definitely keep an eye on that. So again, if you guys remember, Wendi Adelson wrote a book. This was back in, was it 2012? 2011 maybe? But remember, Dan Markel was murdered in 2014, if I remember correctly. The divorce stuff was happening like 2013. Wendi wrote this book in, where the fuck is it? Maybe 2011, 2012. It'll say somewhere in this document. So anyways, in this book, essentially, the title is, This Is Our Story. That's literally the title. This is our story. And so a lot of people, who read the book or even read the excerpts, they say that, wow, this book kind of sounds like Wendi Adelson. It's a book about an attorney who apparently was not happy with her life. She didn't feel fulfilled. She wasn't happy in the marriage that she was in. And so she decides to pursue, I think she was helping victims of human trafficking. I think those were her clients. And then through that, she went through a change. And then at the very end, I think she ended up leaving the husband. Now, if I remember correctly, Dan and Wendi were living in Tallahassee. However, in the book, the fictional place was, what was the fictional place again? This Is Our Story. Back in 2011. The novel was published in 2011, about a year before Adelson walked out on Markel with infant children, the bank account, the furniture, and the Markel family heirlooms in tow. Yeah, so apparently Dan Markel, I think he was on a work trip. He came back to an empty house. No wife, no children. Stuff was gone. No money, no furniture. Nothing. You know what's crazy? Dan Markel also was promoting Wendi's book as well. I don't know if he read it though. I think, wasn't there an accusation that Wendi or maybe one of the family members threw out that he didn't even read the book? This Is Our Story is an inartful, shallow, cliched, oddly bland, given its human trafficking theme, and terribly self-important. Thank you, Amon. That's what I'm looking for. Hiawassee Springs. So let's go back to reading the defendant's motion in limine. Storyline of Wendi Adelson's book. Donna Adelson renews her request that this honorable court prohibit the state from questioning Wendi Adelson about the storyline of her book, and in support thereof states as follows. 1. Mrs. Adelson has been indicted on this case with 1 count of first-degree murder, 1 count of conspiracy to commit first-degree murder, and 1 count of solicitation of first-degree murder. 2. Prior defense counsel moved to prohibit the state from questioning Wendi Adelson about the storyline of her book, This Is Our Story. On September 6, 2024, the court denied this prong of August 12, 2024 motion in limine, ruling that the state could use the storyline for purposes of impeachment. Current counsel renews this motion of limine as additional facts were not previously known and or addressed. During August 30th, 2024 hearing, the state argued, I think in reference to the book, this is the one I kind of flip-flopped on because I went back and looked at how it came up last time, which was that Wendi Adelson denied wanting to relocate, denied being disappointed about losing her motions in court to relocate. And that is, of course, the state's theory, as the main motive behind the crime was that she was wanting to relocate to South Florida. And I have thought at the time that testimony opened the door to her having written a clearly autobiographical book about a woman just like herself, married to a man just like Dan Markel, who's utterly miserable and stuck in the place that she's living in. So if the testimony goes that way this time, I can imagine a scenario where I might just want to ask about that. Hey, go Lucky, how are you? All right, so the petition for dissolution of marriage was filed on September 10th, 2012. The motion for temporary relocation, an amended petition adding the court for relocation, was filed on January 14, 2013. The petition for relocation was denied on June 18, 2023. So Wendi wanted to move closer to where her parents were with the two children, and that was denied by the court because Dan Markel was living in Tallahassee. He would have to drive 6 hours in order to see his children. The evidence established that Miss Adelson's book was originally published on September 15, 2011. Even assuming the storyline in Mrs. Adelson's book is autobiographical, how Miss Adelson felt about being stuck in Tallahassee at the time she wrote the book is not relevant to how she felt after her petition for relocation was denied or during the time of the alleged conspiracy. Presumably, Miss Adelson did not start writing this book in September 2011. Rather, it is significantly more logical that Miss Adelson wrote this book over a period of time which was concluded in September 2011. Making it even more remote in the time into the denial of her petition for relocation. As a result, if it does not even survive on Section 90.403 Florida Statute, analysis as its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury. Do you guys remember there was this author who wrote a book about murdering her husband, and then she actually did murder her husband? She was on trial for murdering her husband. Now, I think the state wanted to use the book against her, but they were unable to do so. I would assume the same would probably apply here, even though there was a lot of similarities between the book. I think they can still say that, oh, this is not a book that I wrote about my life. This is a fictional book. What are you talking about? So again, I think we don't have the state's argument yet because this was filed a couple days ago. Waiting for the state to reply. Okay, so order denying defendant's motion to suppress. Again, Donna wanted to have evidence suppressed. It was a phone call that she made to Charlie, and it continued recording, and Donna forgot to hang up the fucking phone. All right, here's some background. November 7, 2023, defendant Donna Adelson received a phone call from Charlie Adelson on her cell phone while she was at home in her apartment. I'll zoom in for you guys. I'm sorry. The caller was her son, Charlie. At the time, Charlie was an inmate of the Leon County Jail, incarcerated there since his arrest on April 21, 2022. One day prior to the phone call at issue, Charlie Adelson was convicted of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Before being permitted to speak with her son, defendant was required to acknowledge the following message and consent to its terms. The message disclosed. Hello, this is a prepaid call from Charlie, an incarcerated individual at Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this call should be private, please hang up and follow facility instructions. To register this number as a private number. To accept charges and consent to the recorded call, press 1. To repeat, thank you for using Securus. You may start the conversation now. This preamble is a standard notification advising individuals who receive phone calls from the jail that the calls will be recorded. Thus, to speak with a Leon County Jail inmate through this phone system, the non-inmate must give consent to be recorded unless it is a private call. Defendant concedes that she was informed of this notification when she consented to speak with her son on the recorded line. Now, approximately 8 minutes into the phone call, Charlie was disconnected, leaving only defendant's phone still being recorded by the phone system. At that point, defendant says, "Can you hear me? Charlie? Shit, you can't hear me again, right, Charlie? Charlie, can you hear me? I'm sorry. The fourth time that they cut each time." Exhibit 5. She then began a lengthy conversation with the other people who were inside of her home. Given that defendant was conversing with people other than her son, referring to her son as he and him while talking about him, and revealing the facts that she did not have the heart to tell him, the court is convinced defendant subjectively believed her shared phone call had ended and had ensuing conversations private. Subsequently, dude, over the next 15 minutes, oh my God, Donna. Subsequently, over the next 15 minutes, defendant alluded to committing professed that she was looking for countries that did not have extradition agreements with the U.S. wondered whether Vietnam had an extradition agreement with the US, and spoke about a conversation she had with her daughter, Wendi Adelson, about giving her papers and wills. Oh boy, oh boy, oh boy, oh boy. Eventually, someone other than defendant realized the phone call had yet to end and ended the call. It was only at this point that the phone call terminated. The recording stopped. Investigator Jason Newland testified this is standard protocol for phone calls originating from Leon County Jail. Okay, so who was Donna with? We're about to drop some names. Those people were her husband, her attorney for her estate planning, Susan Brotman, and Miss Brotman's husband, Richard Chagrin. Defendant testified that Mr. Chagrin is not an attorney. While the issue of privilege is not raised through this motion, a recognized privilege can be waived by voluntary disclosure or consent. Oh boy. Defendant argues that it was unlawful warrantless interception to record her conversation after Charlie Adelson was disconnected because she believed the phone call and the recording had ended. Oh my God. Dada. Oh man. All right. Analysis. Before a trial court will consider the merits of a Fourth Amendment motion to suppress, the defendant must establish a factual basis justifying his or her claim to possess a Fourth Amendment right at the time of the alleged invasion. Regarding oral communications, for an oral conversation to be protected under Section 934.03, the speaker must have an actual subjective expectation of privacy, along with societal recognition that the expectation is reasonable. Listen, if you forget to hang up the fucking phone call, that's on you. That is on you. Defendant argued in her written motion that the state bears the burden of justifying its alleged warrantless interception and moved to suppress the oral communication she uttered after Charlie was disconnected from the phone call. However, the written motion misstated the burden of proof because Fourth Amendment search does not occur even when the explicitly protected location of a house is concerned, unless the individual manifested a subjective expectation of privacy in the object of the challenged search, and society is willing to recognize that expectation is reasonable. As a result, it is the defendant who must first establish a search occurred within the meaning of the Fourth Amendment. See some case laws. Therefore, to support suppression of a communication under a wiretap law, the person who made the statements must show more than a subjective expectation of privacy. They must show that they have a reasonable expectation of privacy under the circumstances, which depends on one's actual subjective expectation of privacy, as well as whether society is prepared to recognize that expectation is reasonable. Because the court concluded defendant did subjectively expect her conversation was private, this motion turns on whether society is prepared or willing to recognize each subjective expectation as reasonable. After concluding a thorough analysis, the court has determined defendant's conversation did not constitute the unlawful interception of an oral communication under Section 934.06 Florida statutes. Oh man. Reasonable security measures of Leon County Jail. To ascertain whether society is prepared or willing to recognize the defendant's subjective expectation of privacy as reasonable, the court begins with a well-established principle that citizens are guaranteed a reasonable expectation of privacy in their own homes. Yeah, but however, it's like this call was recorded and then you forget to hang up. Sucks, Donna. Sucks. It's like, yeah, the call was made in your house, but you know, there are issues. You forgot to hang up the phone. All right, so the defendant relinquished her reasonable expectation of privacy when she answered her phone and consented to speak with her son. Defendant argues that she regained a reasonable expectation of privacy previously relinquished through consent once her son was disconnected, but she did not actually terminate the phone call from her end. During the hearing, the state contended that the primary basis for denying defendant's motion to suppress was that it did not intentionally record the defendant's conversation. The court disagreed. The Leon County Jail intentionally utilizes technology developed by the company Securus that, by design, continues to record conversations between inmates, call recipients, until both parties disconnect. If the decision to record prior to the inmate's disconnect is intentional, as the state arguments concede, it stands to reason the decision to record after the inmate is disconnected is also intentional. However, in determining whether expectation of privacy is reasonable, the court should examine the location of the conversation, the type of the communication issue, and the manner in which the communication was made. Although the location of the defendant's conversation occurred within her home after her son was disconnected, the fact remains she consented to receiving a phone call from jail facility. The type and manner of the communication are also quite different from ordinary phone calls. This phone call, 1, began with message stating that it was not private. 2, requiring acknowledgement that it was recorded. So you press 1, which is what she did. 3, required consent to proceed, and utilize third-party technology to facilitate recordings between inmates and non-inmates. Even if many modern cellular phone devices typically terminate a phone call when one party disconnected, as defendant stresses, communications from jails and correctional facilities have a unique institutional safety concerns that are not at issue in common communications between non-inmates. Thus, defendant's subjective expectation was built on a false assumption that drop calls involving the Leon County Jail have the same results as drop calls involving at least one cellular phone. This assumption is unreasonable given the concerns correctional institutions and jails encounter. We talk about a federal court of appeals, some other cases. I sort of hop onto the Donna stuff. Loopholes, federal courts have opined. Defendant's subjective expectation conflicts with her own knowledge. Ooh, tell us more. Charlie was arrested April 21st, 2022. The portion of the conversation defendant seeks to suppress occurred on November 7, 2023. That period spans a difference of 565 days. Based on the sheer volume of calls between the defendant and Charlie Adelson, she cannot reasonably claim to be unfamiliar with how the Leon County Jail facilitates phone calls from inmates. Oh, gosh. This asserted subjective expectation became less and less reasonable with each time she answered a phone call from the jail, consenting to recorded calls until both parties are disconnected. She cannot even claim to be unfamiliar with what transpires at Leon County inmates' phone is disconnected because she is heard acknowledging on November 7, 2023, recording that her son had been disconnected for the 4th time. Defendant testified her son was frequently disconnected during the phone calls he made from the Leon County Jail. During these other instances, defendant answered she would ordinarily hang up after the phone after he was disconnected. Hang up the phone after he was disconnected, suggesting she realized she needed to hang up the phone to end or terminate the calls. Yep. Thus, rather than expecting her phone would automatically disconnect, her own testimony reflects that she was aware that calls from Leon County Jail would continue unless she hangs up her phone. Oh boy. Expecting an opposite result or outcome for what has taken previously or repeatedly is an expectation society is unwilling and unprepared to recognize as unreasonable. Conclusion. For these reasons, the court cannot conclude society is prepared to recognize a reasonable defendant's subjective expectation of privacy in the November 7, 2023 phone call. 1. The phone call was received from a jail or correctional facility with a valid interest in preserving security by continuing to record phone calls until both parties of the call have disconnected their phones. 2. Defendant's subjective expectation was contrary to her familiarity with the jail phone technology and prior user-based knowledge. 3. Expecting different outcomes or opposite results from what has repeatedly occurred is intrinsically unreasonable. It is ordered and adjudged in bold and caps. The defendant's motion to suppress is hereby denied. I wonder if Donna remembered to hang up the fucking phone. I wonder if they wouldn't have been able to catch her at the airport. Would she have been able to leave and go to Vietnam? Man, she really screwed herself over. Lady, how are you doing today? That's right. So Donna wanted to be out on bond. Again, Donna talks about how she has had some very unfortunate incidents with other people that are incarcerated. There was one woman who ran her fingers down Donna's spine while they were showering. There was another woman who, I think Donna was brushing her teeth. She grabbed Donna's arm, yanked it up backwards. It hurt a lot. And the woman said that, okay, from now on, you're going to give me commissary. And Donna apparently said that she was going to. Now, I do have questions about the commissary thing because apparently she didn't tell Harvey why she wanted commissary. She told Harvey she wanted commissary because the food fucking sucks and it's disgusting. So I wonder, what if she did want commissary or extra commissary because the food was disgusting, and then later on she retrofitted to a story that could benefit her? I don't know. I just think about stuff like this because Donna is just a very manipulative person. I feel like it's hard to take her at face value. She's always up to something, but maybe something did happen to her while she's being incarcerated. So anyways, she was saying that she's being bullied by these girls. She had to give them commissary. She mentioned how the mattress was uncomfortable, how she has, she's got back issues or something, or I forgot what it was specifically. I knew what condition that she had. I forgot what it was, but she had a hard time sleeping at the jailhouse because of the times that she has to take the medication, and it's like really loud. She can't get good sleep. She's like on like barely any hours of sleep. The food sucks, and she has like these like issues with earwax that builds up, and apparently she has a hard time hearing the guards. They think that she's disobeying them, and she needs to have a special ENT that flushes her delicate little ear canals every 3 to 4 months. She can't get that in jail. There's a lot of stuff that Donna's just having issues with, and you know, being in jail, yeah, it probably fucking sucks. Anyways, so let's get to the judge has denied the motion for the bond slash to set the bond slash Arthur hearing. So Donna was like, you know, jail fucking sucks. I want to be out on bond, and I want to be, you know, monitored. I want to be in my safe comfort home. You know, I think maybe Harvey relocated somewhere closer to where Donna's being held, because again, this all happened in Tallahassee, which is about 6 hours away from where Donna and Harvey normally live. So I think Harvey did buy somewhere or is living somewhere that's closer. That way he'd be close to Donna, or like maybe gets to visit her. I'm not quite sure. But Donna was like, I'm not a flight risk. What are you talking about? I mean, so what that you picked me up at the airport? I was on the way to Vietnam, one-way ticket, you know, non-extradition country. So fucking what? I'm not at flight risk. What do you mean? Y'all took my passport away. You know, there's no way I can leave the country. There's no way I can run away. So Donna wants to be out on bond, but of course that has been denied. All right, so the defendant sought review of her bail status based upon State v. Arthur. The court has reviewed the evidence admitted during the February 26, 2025 hearing, the arguments of the parties, the court file, and being otherwise fully advised in the premises, finds, and the judges as follow. By the way, if you guys have not seen the hearing that took place a couple weeks ago, it was very interesting. It covered so much stuff. So basically, we're looking at all the documents now that pertain to it. So if you guys haven't already, we should have a Donna Adelson playlist that should have that. I don't know. I think I should start including the live streams on there too, because sometimes I don't always chop up the live streams. I go live once a week at least at a minimum. Unless there's like a bunch of stuff that I have to cover, but yeah, I do go live once a week. Join the Discord. I put the notifications on Discord all the time. And then for YouTube, you just have to have the notifications on for, I guess, all. I don't know what personalized means. But yeah, there's 2 ways you can get notifications if you like. All right, so order denying the motion to set bond / the Arthur hearing. Defendant is charged by indictment with a qualifying offense, first-degree murder. The state has come forward with a showing that the proof of guilt is evident or the presumption is great. The evidence from Charlie Adelson's trial, viewed the light most favorable to the state, demonstrates that 1, defendant's personal and unique motive to assist, cause, or encourage the murder of Dan Markel. 2, the lengths defendant was willing to go into custody battle involving her grandchildren. 3, testimony by Catherine Magbanua directly implicating the role of the defendant in the payment of the murder for hire. Again, Katie Magbanua said, well, the money I got was washed. Someone literally washed the fucking money. And usually washing the money, if you guys ever watched Ozark, washing the money is like taking money that was made illegally and then like putting it into the system where it's like into your legit businesses. But Donna literally just washed the money. She literally washed the money because she didn't want, I guess, her DNA or something on there. But anyways, number 4, payments made by the defendant to alleged co-conspirators following the murder. 5, text messages, cell tower analysis demonstrating defendant's movements on the night of the murder. And 6, defendant's conduct after law enforcement bump operation. Man, they didn't have so much evidence against Donna. Oh, Donna, you're so screwed. Defendant also exhibited a conscience of guilt when she attempted to flee to Vietnam prior to arrest using an emergency fast-track visa. This evidence of flight is admissible as consciousness of guilt where sufficient evidence exists to establish the defendant fled to avoid prosecution. Also, again, guys, you guys haven't listened to the prior hearing. Listen to the prior hearing. It was very interesting because they also got into, I think, the WhatsApp messages between Donna and the person that was trying to do like the fast track visa thing for Vietnam. Like Donna was like, I need this now. Give it to me now. And she's like, I need to get the fuck out of here. After the state meets its burden regarding Arthur, the court still retains the discretion to grant or deny bail. When determining the issue, the burden is on the accused to demonstrate that release is appropriate. It is with regard to this question that consideration of the likelihood that the accused will flee, regardless of the sureties required, becomes appropriate. In reviewing the evidence admitted during the hearing and applying the bail criteria of the Florida statutes, the court finds that one of the primary considerations of bail, ensuring the appearance of the criminal defendant at subsequent proceedings, cannot be met. One day after Charlie Adelson was convicted of first-degree murder and other crimes, the defendant discussed fleeing to countries without extradition to the United States. And it's crazy because when I initially heard about Donna discussing fleeing, Donna maybe ending herself, Donna trying to go to a country with no extradition, and what else was there? Was that it? I thought she was just being really dumb and just told Charlie on the phone call because she was like, I don't give a fuck anymore. But I didn't know it was because she forgot to hang up the goddamn phone call and it was recording everything. That same day, defendant communicated with Vietnam Visa Indochina Sun Travel through what she believed was a secure communication application, WhatsApp. Trying to acquire a fast-track emergency visa for Vietnam. Wanted it the fastest she can get it. The purchase of a one-way ticket. She bought a one-way ticket. What, you couldn't even pretend like you were gonna come back? Like, you could at least, I know round trip is more expensive, Donna, but Donna's trying to be cheap, okay? Donna, you should at least bought a round trip. Like, round trip, just be like, hey, I'm planning on coming back. But she bought a one-way ticket. Her and Harvey bought a one-way ticket. Seeking a fast-track visa for extended stay in a country without extradition clearly demonstrates an intent to flee. The court does not find the testimony offered by the defendant during the evidentiary hearing on this subject to be credible considering the evidence. Additionally, defendant's discussions of self-harm further negate the possibility of appearance for subsequent proceedings as directed by the court. Oh no. Man, I don't know if Donna expected that to be used against her. The issues raised by the defendant concerning her conditions of confinement can be addressed directly through administrative and/or civil remedies. The testimony and evidence during the hearing clarify the reasonable measures taken by the sheriff's office to address the defendant's concerns. Defendant is not being denied access to counsel or opportunity to prepare for a trial. Yeah, because Donna claims that she was having issues with other inmates, and then when the jail found out, they basically put Donna in what's that word? What's the word I'm looking for? When you're kind of like by yourself, you know? Yeah, solitary confinement. Okay, that's what she was alleging. She's like, yeah, I'm getting punished and I'm being put in solitary confinement now. But they were like, well, is it quieter there? She's like, yeah. Okay, so you could probably sleep better there. And then they were saying that, oh, well, now, because she was complaining that she didn't have privacy because there was other inmates looking over her shoulders and stuff like that. And they're like, well, now do you have your own space to work on your legal stuff? And she's like, yeah. They're like, okay, cool, then you're fine then. All right, so what else we got here? The issues raised by the defendant, blah, 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 blah. Defendant's not being denied access to counsel with the opportunity to prepare for a trial. The court also notes the defendant has undergone extensive trial preparation prior to the continuance of the trial on September 17, 2024 through the present. So sorry, Donna, you are not going to be out on bond. You're not going to be out with Harvey. And Donna, the incriminating evidence, the phone record, it's going to be, they're not going to suppress it. Donna's not having a good day. So that's a lot for Donna. I hope I have covered everything. That's Donna right there. Donna's not happy. If you look at my thumbnail, it's motion denied. Denied. Donna's not a happy person right now. Now, we have to wait for the state's reply to see whether or not they're going to allow the storyline of... the state's reply for their argument about Wendi's book, if, why the storyline should be included when they're trying to question Wendi, and then we'll wait for the judge to make his decision. And then the other one was the divorce filings. Donna doesn't want the 560 pages divorce filings of Dan Markel and Wendi to be included as an exhibit. The state was saying that, it goes to the motive of Donna Adelson, and it's because she hates Dan Markel. Dan Markel didn't want her to be around the grandchildren by herself because she was saying all these things. I forgot what the statements were exactly. I remember there's something about her calling the children sunshines or sunflowers or something like that, and how their daddy was big stupid or something silly like that. Kids will definitely out you if you say something like stupid daddy. Yep, kids will repeat. Mm-hmm. Yep. And you know what's interesting? Charlie testified about that. Charlie was like, I have a 5-year-old, and 5-year-olds, they don't know what they're talking about. They don't know. They don't know. They don't know how to repeat things. It's 5-year-olds. Yeah, they do. I've seen 2-year-olds, something happens at daycare, they come back and they say the same thing. You're like, where'd you hear that from? But I do remember Charlie trying to testify saying oh, my 5-year-old, he doesn't know, blah, 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 blah. No one cares, Charlie. Fuck off. Oh, wait, Virtus. Yes, Virtus. Okay, Virtus got it. What cracked me up is Charles said the kids didn't say it. There were 3 and 4. They don't talk like that. My 3 and 4-year-olds would definitely say, yeah, I think he said it was like his 5-year-old. Mm-hmm. Hey, Virtus, how are you doing today? I think she's actually in the medical ward, was essentially the same thing. Is she in the medical ward? I thought she was like in like the isolation area. Or, I don't know. She said it was like a solitary confinement. So I think tomorrow we'll get to see Donna Adelson tomorrow, maybe, possibly. Motion hearing, we've already seen that. Okay, so we are ready for Donna Adelson tomorrow. Case management. Take care. I will see you guys. Feel free to join the Discord. We have notifications that will go off for that as well. And then for YouTube, for notifications, you just have to do all, I guess. I don't know what personalized means. I'll look it up later on. But anyways, have your notifications on so you guys don't want to go live. Other than that, take care. Have a good one. I mean, I guess I should make a... Emily Baker does a thing where she has like scheduled live streams, which I should do. But here's the thing, like sometimes the scheduling doesn't schedule. It doesn't happen because sometimes shit pops up and I have to do something and it gets pushed back. I don't know. Maybe I should do more scheduled lives because she does that. I think it's really helpful because people get like a 12-hour notice that she's about to go live the next day. So maybe I could try to do that. We'll see.